Breaking. Supreme Court 9-0. Ruling shocks America. Retirement rules changed forever. Tonight we begin with a decision, a unanimous Supreme Court ruling that legal scholars had feared, financial advisors had warned about, and millions of American retirees had quietly prayed would never arrive. A ruling that unfolded not over years of legislative debate, but in a single morning session. A single morning that reshapes how every working American saves for retirement. A single morning that forces employers, financial institutions, and the federal government to completely rethink decades of established policy. A single morning that places new power and new responsibility directly in the hands of ordinary citizens. What the Supreme Court did today crossed a line that retirement policy experts had hoped would hold for at least another generation. And when that line broke, the financial world did not hesitate. They responded with confusion, urgency, and, for millions of Americans, something that looked very much like hope. For years now, there had been signals, not in official press releases, not in formal congressional hearings, just whispers, that the nation's highest court was preparing something seismic in the world of retirement law. The Supreme Court has been deliberate, yes, but they have been remarkably bold in their deliberateness when it comes to financial cases. Their rulings have followed a certain pattern, a rhythm, almost a philosophy. But what set off alarm bells in Washington and on Wall Street this term was that the usual pattern went silent. Legal analysts who monitor the court's docket know the indicators, the types of cases they agree to hear, the questions they ask during oral arguments, the amicus briefs they invite from government agencies, the sudden recusal announcements that narrow the bench, all of that went quiet. And whenever the Supreme Court goes quiet on a topic as sensitive as retirement security, it means something is about to get very loud. Retirement law in America has always been a battleground. Since the passage of ERISA in 1974 and the birth of the 401k in 1978, the rules governing how Americans save, invest, and access their retirement funds have been subject to constant legal interpretation. But the fundamental architecture, contribution limits, tax treatment, employer obligations, withdrawal penalties, has remained largely intact for decades, until today. Early this morning, the Supreme Court of the United States released its opinion in a landmark case that legal observers had been tracking for 18 months. The ruling was 9-0, unanimous. Every single justice, conservative, liberal, and moderate, agreed. The case centered on a challenge to federal regulations governing required minimum distributions, or RMDs, the mandatory annual withdrawals that Americans with tax-deferred retirement accounts must begin taking after a certain age. The court found that existing regulations, as enforced by the IRS and the Treasury Department, had exceeded the authority granted to those agencies by Congress. These are the kinds of rulings that financial institutions only begin to fully process when they realize that three things are happening simultaneously. Existing enforcement mechanisms are invalidated. New legislative frameworks must be built from scratch. And millions of Americans are suddenly standing in legal and financial limbo. Observers didn't know which category of impact would be felt most immediately, or whether all three would hit at once. But what they did know was that the Supreme Court was changing the entire posture of retirement regulation in America. And when the nation's highest court shifts posture unanimously, without dissent, even by what might seem like a narrow procedural ruling, the entire financial world pays attention. The reaction issued by financial regulators tonight was not routine. It was not symbolic. It was not a form letter. It was urgent guidance. Analyst after analyst appearing on financial news networks and in emergency briefings with clients described the Supreme Court's move as unprecedented in scope, potentially destabilizing in the short term, and perhaps most importantly, deeply liberating for retirees who have been forced to take withdrawals they didn't want or need. But disruption only creates opportunity if the public understands what has changed. The average American retiree did not hesitate to ask the right question tonight. What does this mean for me? In fact, their response today, their flood of calls to financial advisors, their questions to account managers, their engagement with this story, was among the most remarkable public reactions to a Supreme Court ruling we have seen in decades of retirement law. Here is what we know. Within hours of the ruling's release, the IRS issued an emergency notice suspending enforcement of current RMD rules pending congressional action. These weren't routine administrative updates. These were emergency suspensions, the kind of regulatory freeze that agencies only deploy when they are preparing to fundamentally restructure a system that affects tens of millions of Americans. Tonight, sources confirmed that the Treasury Department launched an immediate review of all retirement-related regulations, including enforcement guidelines that had recently been updated under the Secure 2.0 Act, changes that analysts believe were themselves legally vulnerable under the reasoning the court applied today. The ruling struck before Congress could act. It affected required minimum distribution age thresholds. It affected penalty structures for early withdrawal. It affected inherited IRA rules that were already confusing millions of families who had received accounts from deceased parents or spouses. In other words, the court targeted the entire enforcement infrastructure of retirement taxation, the legal mechanism that would have made those rules operational going forward. This is what made financial advisors' warning so urgent tonight. The Supreme Court's ruling wasn't just symbolic, it was immediately actionable. It represented the kind of legal vacuum that, if left unaddressed by Congress, could allow individuals to stop taking required minimum distributions entirely, keeping more money inside tax-deferred accounts, growing tax-free for longer than any current law permits. And the financial planning community, understanding that fully, responded with preparation rather than panic. Not recklessly, not impulsively, but strategically. They didn't tell clients to do nothing. They didn't tell clients to immediately restructure everything. They told clients to wait for clarity and to understand that for the first time in decades, the wind may finally be blowing in their favor. And here is where the story becomes even more significant. Legal scholars now believe that the Supreme Court's ruling was designed to fundamentally test the limits of executive agency power in the realm of personal finance, arriving at a moment when public trust in federal financial institutions is at historic lows. The court wanted to see whether regulatory agencies had been operating beyond their congressional mandate, and the answer, in the eyes of all 9 justices, was yes. Retirement law experts speaking with financial media outlets described the court's reasoning as a masterclass in the major questions doctrine, a legal principle that says agencies cannot make sweeping, economy-wide decisions without explicit congressional authorization. But the ruling proved today that the court remains both principled and precise. Their analysis was not only legally rigorous, it was targeted so specifically that it addressed RMD rules without dismantling the entire retirement savings architecture. That precision matters because it shows the court is not attacking retirement savings. It shows that the court is not trying to eliminate tax-advantaged accounts. They are protecting the individual, not the bureaucracy. As reports continued coming in throughout the day, we learned more about the scale of what this ruling touches. Americans aged 73 and older are currently subject to RMD requirements on traditional IRAs, 401ks, and most other tax-deferred accounts, roughly 17 million people directly affected. Inherited IRA holders, a group that exploded in size after the baby boomer generation began passing on wealth, face rules that had already been legally contested in lower courts. Financial institutions operating under federal oversight will now be required to update every disclosure document, every compliance protocol, and every automated withdrawal system that currently enforces RMD rules. This wasn't just a legal footnote. This wasn't just a policy adjustment. This was a structural reset. This was a declaration of individual financial sovereignty. And financial sovereignty is the one thing American retirees have struggled to maintain since the 2008 financial crisis first shook their confidence in the institutions managing their money. For every regulation added in the name of protecting retirees, Congress had inadvertently built a system that forced seniors to liquidate investments on government schedules rather than personal ones. Remember, Congress thought the Secure Act of 2019 had settled the RMD debate. They thought Secure 2.0 in 2022 had modernized the system fairly. They thought regulatory agencies had the authority to fine-tune implementation as they saw fit. But tonight, the exact opposite has been declared. The agencies overstepped. The regulations exceeded congressional intent. and millions of American retirees now stand at the threshold of a new legal landscape. What makes this moment so powerful and so politically charged is that the Supreme Court's ruling arrived at a time when Congress is under enormous and competing pressure regarding retirement security. Progressive legislators want expanded Social Security benefits. Fiscal conservatives want reduced federal exposure to retirement obligations. Financial industry lobbyists want regulatory stability and predictability. And ordinary Americans, the ones who have spent 40 years contributing to 401k plans, want the freedom to manage their own money on their own timeline. Congress is now being forced to balance these demands while simultaneously drafting emergency legislation to fill the legal vacuum the court has just created. And when legislators in that position must act under deadline, they rarely do it from a position of careful deliberation. They do it from pressure. They do it from political vulnerability, which means the legislation that emerges from this moment will be shaped as much by fear of public backlash as by sound financial policy. The IRS's emergency notice, now distributed to every major financial institution in the country, was designed to signal that the federal government is not willing to allow enforcement chaos in the absence of clear legal authority. Treasury officials said plainly that the existing RMD enforcement framework was now inconsistent with current judicial interpretation of congressional authority. That is careful legal language for, we know the rules just changed, and we are not going to penalize anyone while Congress figures out what to do next. You do not usually hear that tone from the IRS unless something very serious is at stake, and something very serious is. Meanwhile, the lead attorney who argued the winning side before the Supreme Court addressed reporters in a brief, composed, and remarkably pointed statement this afternoon. He said, "This ruling returns to the American people the right to make decisions about their own retirement savings without being forced to act on the government's timeline." He said, "We are not here to destroy the retirement system. We are here to make sure it serves the people who built it." And he said, "No American who spent a lifetime saving should be penalized for wanting to leave more to their children." These are not rhetorical flourishes. These are statements from an attorney representing millions of Americans who understand exactly how high the stakes have become. Here is what makes the situation even more consequential. Today's ruling was not isolated. Alongside the primary RMD decision, a separate lower court ruling in the Fifth Circuit extended related logic to inherited Roth IRA rules. Congressional budget analysts began revising long-term revenue projections that assumed RMD income would continue flowing into federal coffers. Major brokerage firms began revising their automated RMD distribution systems that manage billions of dollars in annual withdrawals. All of this happened within the same 24-hour window. When the court, the lower courts, and the financial industry all move simultaneously, it means something larger is underway. Financial planners are now considering several scenarios. One is that Congress moves quickly, passes clean legislation explicitly authorizing modified RMD rules, and the disruption is short-lived. Another is that Congress gets gridlocked in partisan negotiation and the legal vacuum extends for months, giving retirees a de facto holiday from forced withdrawals. A third possibility, the one worrying tax revenue analysts the most, is that Congress fundamentally restructures RMD requirements, pushing back the starting age further, reducing mandatory amounts, or eliminating them for accounts under certain balances entirely. But today, the Supreme Court took the status quo off the table. They didn't issue a narrow ruling, they didn't leave a workaround, they didn't give agencies room to simply rewrite the regulations on their own authority. They delivered a 9-nil mandate. What we are watching now is a test of institutional responsiveness. Congress wants to show it can act swiftly and decisively. Retirees want to see that their financial future is not collateral damage in a legal dispute. The Treasury wants to prevent a tax revenue shortfall. And the American public wants to believe that a system they spent decades trusting with their savings is still worthy of that trust. Tonight, financial advisors across the country are now scheduling emergency client calls. They say the most important thing retirees can do right now is nothing hasty. They say existing withdrawal plans should remain in place until formal congressional guidance is issued. And they say the Supreme Court's decision to rule unanimously is likely part of a broader judicial philosophy intended to restore individual financial autonomy in an era of regulatory overreach. But retirees are not panicking. In fact, many are cautiously optimistic for the first time in years. Their response today, patient, attentive, and engaged, sent a message to Washington that they are watching, that they are informed, and that they will hold their representatives accountable for whatever legislation emerges from this moment. As the days ahead unfold, we expect more details to emerge about what exactly federal agencies will do to restore legal clarity. But what we know is that the Supreme Court's unanimous ruling was timely. It stopped decades of regulatory overreach from continuing unchecked. It gave millions of American retirees a moment to breathe and to reconsider what retirement freedom could actually look like. And it forced a long overdue national conversation about who controls your retirement savings, you or the government. What happens next will depend entirely on how Congress responds in the coming weeks. If they act responsibly and pass thoughtful legislation, this moment will be remembered as the turning point when America got retirement policy right. If they stall or overreach, the Supreme Court has already shown it is ready to act again. And tonight, for the first time in a generation, Washington appears to be on the defensive when it comes to your retirement. The IRS is quiet. The Treasury is quiet. Too quiet. And when federal agencies are quiet, it means they are calculating. It means they are choosing their next move very carefully. Because tonight, Washington learned something millions of retirees have known for a very long time. Your money is yours. Your timeline is yours. And a unanimous Supreme Court just put that in writing. This story is far from over. But tonight, one thing is absolutely clear. The retirement rules have changed. The power has shifted. And the American retiree, for the first time in decades, may finally be holding the winning hand. We will be here, watching every detail as the next phase of this historic ruling unfolds.